All right, so it's 6 o'clock, and you're welcome to today's episode of The Lawyer's Diary. Our topic today is on intellectual property rights and then the creative arts. Our speakers are from two diverse backgrounds. One is an artist and a reporter, and the other is a lawyer and an editor of a digital media, which is the Ghana Law Hub. So our first guest is lawyer Samuel Kofi Nete. Well, Kofi Nete is the editor of the Ghana Law Hub, an online digital legal directory, and then an associate at Law Plus, one of the fast growing law firms in Ghana, and currently is doing his master's in the UK in the area of intellectual property law. So I couldn't have chosen any better person than him. I've done some major works with Lawyer Nete, and I know his capabilities, and I hope that today's episode will indeed bring out a lot of things that we all yearn to know. The next guest is Kwao Leslie Stites. Kwao is an artist manager and a repertoire. He's more into talent hunt and development. He's currently a director of the Mike Brothers music production and is also the manager of Amrado Bena, one of the shining stars in the music industries in Ghana, who brings up entertainment in the form of rap music every week. So, Lawyer Nete, welcome to today's episode. Lawyer, welcome.
Thank you, Onesimus.
Sure, and then Kwao, welcome.
Thank you, big man.
Sure. So we'll zoom straight into action because of our timing for lawyer. He's asked that we limit everything to the proposed 1 hour, so we won't be exceeding it. The lecture will be more of a 45 minutes discussion, and then from there we can zoom straight into some of the questions that any of us may have for him to answer. But before we continue, today's episode is sponsored by Goal Achievers Company Limited. Goal Achievers Company Limited, they're into wallpaper, bioflow, digesters, installation, 3D epoxy. You can contact them. Their numbers are displayed on the wall. In the course of the program, we will again bring them so you contact them. So, Nete, let's zoom straight into action because of your time. When we say intellectual property rights, intellectual property law, what is it? Please throw more light on it. What is intellectual property?
So, intellectual property basically is a branch of law that protects the product of the mind. So, when we talk about the product of the mind, we are talking about inventions, literary work, artistic work, symbols, names, images, and designs which are used in commercial environments. And this primarily is because the law assumes two theories underpin this area, one of utilitarianism and the other one of natural right. When we say utilitarianism, we are saying that if the society protects the rights of inventors or creative artists, it will lead to a situation whereby they would produce quality goods, which would then mean that the society will benefit generally. So for instance, if somebody always comes up with good music or a good painting, and society does not protect it, that music or painting, the incentive for the person to go back and do that music again, that good music or do that good painting again, is minimal. So the person will not go back because he knows that when he brings quality work, you guys are not going to protect it. So the mind of the person, the product of the mind will not be protected, and the person will go back. So that is the utility side. Then the natural right is the fact that everybody has a right to earn income from his property, or everybody has a right to own property. So just like normal you have the right to buy your own land and build your own house. You have the right to buy your own car and own it. You have the right to buy your clothes and own them. Intellectual property in creative work is the same. So the moment you develop something, the assumption is that you should have the natural right to own it. So basically, that's the what intellectual property is about.
So there are two concepts that guides intellectual property rights in terms of the natural law that you just mentioned, and then the utilitarian stuff.
Yes.
But what I want to find out is that you mentioned symbols and names. Does it then mean that when names are being used by an individual, same cannot be used by another because same belongs to the individual that first used it?
Okay, so let me just say let me just try to say that intellectual property covers various areas. So before I get to that question, answer that question, it will be proper to situate it in context. Now you have what we call patents, you have what we call trademarks, you have what we call copyright, and we have what we call geographical indications, and we have what we call confidential information. So these are intellectual property cuts across these basically these five areas. Now, patent refers to protect inventions or inventions relating to technology or other industrial products which are very novel. So for instance, the person who develops the bulb that we use or the computer, the chip in the computer has a patent on the chip so that his right is protected, so that nobody goes around and copies his work and develop the same thing. Now we realize that it takes a lot of time and effort to develop something. So recently, I think when coronavirus came, we all had a Ghanaian professor, Bagonluri at Academic City, saying that he was developing a respirator. Now, he took a group of students and started developing a respirator from scratch, from local materials. Now that in itself becomes, because it will take time. So usually maybe a very long time before the product comes out. Now, if the product comes out, or even medical research, now the cure for coronavirus has started for about 8 months now. Cure for AIDS has started more than 20 years. They have not still found a drug. So once you develop it, it becomes new on the market. You have to protect it. So you patent the work in terms of what are the compounds that you use to develop the drug, so that nobody can copy that and reproduce it without your consent. You understand what I'm saying? Then you relate to trademarks. Trademarks goes with marks or names or symbols that is supposed to distinguish between one manufacturer or goods from the other seller or good. So back to your question, what you are talking about relates more to trademarks. So Coca-Cola has a trademark. The Coca-Cola bottling company has a trademark in the word Coca-Cola. It has a trademark in the shape of the bottle. So you cannot develop any soft drink or any drink and put it in the Coca-Cola bottle, because that anybody who sees that Coca-Cola bottle, even without the mark, knows that this is what a Coca-Cola. You get it? So the mark distinguishes the product from another product or from another manufacturer. So you cannot put water in a bottle and then call your water Coca-Cola, for instance, because Coca-Cola has a trademark in the name. Then we go to copyright. So copyright, for instance, copyright deals with protecting the work of artists, performers, literary works, and all other persons. So this area protect these persons. Now we have to distinguish, for instance, between who an author is and who the owner of the work is. Now, the author is the first person and first owner of the work. So the author is usually the person who does the work. He brings the work into fruition. The owner may not be the author. So, for instance, we all know a particular the Sarkodie's album, for instance, the Mary album. When you pick maybe a sort of musician's work, the person has, if you pick the label, you see maybe Arthur. So the person, the songwriter, then the musician, the singer of the song, and then the composer. Now, probably the person who develops the work writes the lyrics and gives it to the singer to sing. Or somebody, the person sings the work and says, okay, I'm giving it to you to use the song to develop. So in this political season, many musicians will be approached by political parties to develop songs for them. Now, the moment that the musician develops the song, he's the author of the song. The moment he gives it to the political party becomes what? The owner
of the song.
So the owner of the song is the one who enjoys the royalties, not necessarily the author. Because the author may have assigned his rights. So the author may say that because I'm working on this song for you, pay me this amount of money. And then you pay the money. The moment you pay your money, you assign your rights. So maybe I've assigned my rights for 5 years. So for the next 5 years, I'm not going to earn any royalties from the work. And then the owner then becomes the owner of the work. So the owner necessarily cannot be the author. Then there's another branch of IP which you call confidential information. So this kind of work sort of protects trade secrets. So you go to a place like maybe Papaya or Frankie's or any other restaurant, for instance. You realize that the taste of Papaya shito is different from any shito you have in Ghana, isn't it? So they have their secret formula that they prepare using preparing this shito. You cannot come across this preparation, this recipe, and reproduce it without their consent. Or so you are working for them. You come across this information and then you go adapt it and use it as your own product. It doesn't work that way. And then also you have what we call geographical indications. So this is an area that sort of protects goods from particular regions. So the idea is that the goods that come from a particular region have certain characteristics, or the area or the territory where the good is produced has certain characteristics that has a bearing on the product. So for instance, you cannot use the word champagne on any other product, because champagne is wine developed in a part of France. So because of that, when you use champagne for any other thing, you devalue the meaning of champagne. So if you pick wine from a champagne from some part from France, that taste is different from the one you drink from South Africa. The same applies to tea. Maybe tea from India, or what probably you are more famous with what we call basmati rice. Basmati rice, for instance, you cannot have rice grown in Ghana and call it basmati, because basmati is associated with India, and so that is how these are the areas. So to your question, the question more relates to trademarks as one of the areas in intellectual property.
Okay, Samuel, thanks for the clarification in terms of the types of IPs that we have. But you mentioned the case of Coca-Cola and then how they've carefully carved their bottles. Is it that they have registered or they have sole rights to how it is carved, or because they've used it for a long time and everybody can associate Coca-Cola with it, that is how come nobody can use it for its product? Okay,
yes. So intellectual property.
It also goes within the champagne that you just said. Yes. I mean, is it that it's been associated with a particular brand conventionally, or they have taken steps to ensure that, say, is linked to their brand.
Yes, so there's a framework for enforcing intellectual property rights, and the framework for protecting intellectual property rights. Now, there's a general law that most countries have signed up to under the World Intellectual Property Organization, which sort of protects intellectual property. But every country has protection for IP rights. So, for instance, Coca-Cola is an American company. So if you go to the American Trademark Office, the Patent and Trademark Office, Coca-Cola has patented and trademarked its logo and the design of the bottle. So when you run a search, you realize because they have registered it, Coca-Cola will ensure that everywhere in the world where Coca-Cola is, they have a right, they have registered that product, so that when they come into Ghana, if somebody in Ghana tries to use that particular product, they can enforce their right against the person. Now, there are situations whereby the person may not have registered the product. So what you usually will call unfair competition and there's a term there's a term for what we call character merchandising. Now, this particular area relates to the fact that maybe the product may not be registered in itself, but because of the way the product has been used generally by people, it is associated with a particular brand, and you are trying to get undue advantage by using it. So, for instance, if somebody who has not registered his product, the person you see the product and you decide to apply for a trademark. The trademark office, the moment you put in the application is not automatically granted to you. The trademark office will publish that this person wants to register his product, or wants to register the name, or wants to register this design. That will be kept for some time. And then people who have an interest may come and object to the registration of the product. So recently, Apple has a big fight with another company called Pear. Now, Pear is a recipe developer. They develop food recipes, so they are trying to put recipes of food on a software, and people can download it and use it at home and for restaurants. Now, Pear's logo is the fruit pear. Apple's logo is apple, which is a bitten apple, to be specific. Now, what has happened is that Apple is saying that the Pear's company's use of the fruit pear will confuse Apple's customers and consumers. So Apple's consumers cannot be able to distinguish between their product and another product, which I find very interesting, because usually
how closer is Pear to Apple?
Exactly. and even
with their own is a bited apple, not just a full apple.
Yes, but even the other area is that they are not in the same industry. So, for instance, if you're a computer manufacturing company and you call yourself maybe Apple In, it may confuse consumers. So you realize that a lot of, when you were in secondary school, what people call Sinte. So somebody is wearing a Nike shoe. Instead of the Nike, the person writes Mike. You should have the shoe Mike.
Okay.
You understand? Or Adidas with a double D. So these are the situations that sort of confuse consumers. And Apple is saying that this particular product is going to confuse its consumer. Although they are not in the same industry, they are not in the same sector. So usually you always have a right to sort of object to the registration of somebody's trademark or patent if you see that it is likely that it will confuse your design.
Okay, now let's get back to the creative arts. What are the things that I need to prove in order to establish that I own this product, this idea, this concept solely belongs to me, and I have the intellectual property right to it? Is there some elements that I need to prove?
Okay,
Is there some steps that I need to take?
So intellectual property for the creative arts, because intellectual property rests on the creation of the mind or the innovation of the mind. Now you are talking about a group of people, so you are talking about artists, actors, directors, producers, composers, arrangers, recording artists, all these painters, all these groups of people. Now, is the work, the first question is the work original? So the originality of the work is important, because you do not want a situation whereby somebody has picked another person's work and copied it. So the first question that you will be faced with is the work original? Now, if the work may not be original, but have you improved on the work? So for instance, Sarkodie has is it this song, is it Chenche Bie Dimewu?
Yes.
Now that song was originally performed by Alhaji K. Frimpong. Then you realize that I think in the early 2000s, I think was it Reggie Rockstone or somebody sampled it, and then Sarkodie and Reggie Rocks and what's his name? This reggae artist. You are the artist. I've forgotten.
Rocky Dawouni.
So Rocky Dawouni and Sarkodie, Rocky Dawouni sample Chenche Bie Dimewu. Now, if you look at the beat of Chenche Bie Dimewu, originally sung by what's his name, Alhaji K. Frimpong, and the beat that Rocky Dawouni and Sarkodie performed, although they sound the same, but there is an improvement on the work. So the first original song, Rocky Dawouni needs the consent of what we call it, of Alhaji K. Frimpong to be able to use that particular beat for his own. Now, the sound engineer who worked on the current beat has added some instrumentations. So maybe in the original song you didn't hear the sound of a trumpet. Maybe there was no guitar in it. But for this kind of work, they added a guitar, they added what do you call it? A trumpet to it. So it changes the character of the what they call it, of the beat. Then you have Reggie Rockstone, we have Rocky Dawouni, who is now singing the work. And then you have Sarkodie who's rapping on the song. So the songs, although they are two different songs.
But Samuel, let's be clear here. That is it the position of the law that once I improve on an original work, I'm not infringing upon it. The reason why I'm asking is that it then gives a leeway for all people, all persons to find just a minor improvement on an original work to relieve itself from any liability. Because say an example is if I want to sing Amachi Dede's song on Emape Soko Nadewo, and I get Amado Bena to put some raps in it, we increase the tempo, we decrease the bass. Am I still not picking or stepping on the original concept to make some means out of it without any economic benefit to the original owner?
Yes. So what I'm saying is that there can be an original owner. You are allowed to adapt the work with the consent of the person. So if you remember when Rocky Dawouni released the track, the family of Alhaji K. Frimpong came out and said Rocky Dawouni had not seek their consent.
So their consent, yes.
You understand? So they were able to establish, because you see every song or every composition has a certain rhythm, it has a certain beat. it has a certain lyric. So the Chenchembie Dimewu word, the string of words, somebody has already used it. So you cannot just take it up and use it with in your work without acknowledging the person, because
still comes back to the first question, that the fact that somebody used it, in our local parlance, there are a lot of proverbs, there are a lot of sayings, which has been there since time immemorial. Chenchembie Dimewu wasn't invented by the person who sang it for the first time, but he used it in music.
Yes. So
exactly.
he used it in what?
In music, in musical works.
Exactly. So you go about going to perform another song and titling it on using the lyrics Chenchembie Dimewu. So you see, you can use Chenchembie Dimewu in a normal setting, but the moment you go into music and you string, so Chenchembie Dimewu, AJ, you understand how the words go. You cannot say that, because that string of words is from you lifted it. So in academic setting, that would have been plagiarism, because you lifted the entire word and placed it in a song. But you can say Chenchembie Dimewu, but nothing stops you from saying Chenchembie Dimewu in a song. But the moment the chorus and everything flows in similar fashion, you realize that.
So for the chorus, choruses can be changed. I mean, in terms of the tempo, in terms of. But are we now saying that if I use it from, say, the straight sentence, that is when I'm caught, or I can use it in bits and pieces?
So the person has to prove that this particular work belongs to me. And how does he prove? He brings out his lyrics and say, look, if you look at the lyrics of this song, the lyrics of this song are my lyrics, because he says A, B, and C, D, and it follows a certain pattern. So you cannot just, for instance, this, I think recently, was it a Ghanaian artist sampled a song of a certain American artist, and somebody reported it on YouTube, and it was taken down. Because he sampled the beats of the song.
Yeah, Mr. Drew
Yeah,
on his the new song. Yeah, the guy was a Nigerian.
Yes, you realize that the beats are different or the same, but
it's featuring Stonebwoy.
Yes, he sampled the beats, just changed some things, and I'm saying that, you see, you can do the work, you can adapt the work, but you need the permission of the author to be able to adapt the work, because the moment you adapt the work, and you have the consent of the author, it also becomes yours.
Okay.
So that the next person who is also changing it cannot change it without your consent.
All right. So I'll come back to you. Kwawuleze is he's an artist manager, an artist himself, and also manages Amara Bena currently. So Kwaw, take us through what the kind of things that, as it stands now, either artists or managers experience with respect to either copyright or IP.
Oh, okay. Thank you, and thanks everybody for joining us today. We are really grateful. I'm Kwawuleze, as we are saying, and then today's discussion, I want to ask about production. Like, when producing song for artists, or when song producers are producing song for artists, as the artist is putting down lyrics, the beat is also notes, and it's written. Beats are probably written, there are lyrics too. So at what point in time do we say you are not stealing somebody's beats? Like, example, when you have Kasapa used to have this tone, like kum kum kum, right? So let's say you use that. Let's say you are using that in your beat production. Do you have to seek Kasapa's permission to do that, or that is not taking someone's intellectual property?
So it depends. So for instance, Kasapa's Kokoko has a certain, maybe you are the musician, a certain note is played in a certain note, is played in a certain key. Remember, Kasapa's Kokoko comes from gong gong.
Yeah.
So it may be that the sound of that gong gong comes at a certain pitch or a certain note. Now, if you go ahead and play it at that certain same note and pitch, it could form the basis of infringement of intellectual property. But I'm saying that, for instance, that kokonko sound, that the gong is not exclusive to Kasapa. So the computer is playing it, or your composer is playing it at a certain tone for a purpose of certain beat, and it is in a certain sequence, and it is not likely that it would be subject to copyright. But even back to the question, back to your issue. So maybe in your industry, for instance, there would be say your artist that you manage. The artist is the one maybe who has a good voice, but doesn't know how to write lyrics. So somebody comes and write the song, write the lyrics for him, and then you go to a studio for the sound engineer to work on the song or produce the beat, and then you take it to the producer who masters the song, and then you are the artist manager who put your money in it.
Sure.
The executive producer. So one song, you are likely to have about 5 people who have copyright in this song. So these 5 persons. So for instance, that song, the songwriter has royalties arising out of the work. The sound engineer has royalties. The executive producer has royalties. The producer itself has royalties. So within this area, you cannot just wake up and say one morning when you go and collect money, you don't give the songwriter some. Unless you have, so it is better to always have a contract, because if you don't have a contract, then it becomes an issue that you have to fight over, because one, you don't know whose work it is, because usually intellectual property has what we call joint ownership. So it's allowed that people can own a song or own a work together. So if you have joint ownership, like in this area where it is very difficult for you to separate one person's contribution from the other. In terms of the song right now, I'm able to separate that this is the sound engineer, this is the work he did. So from every song every time the song is played, maybe his interest is 20% of the song. Executive producer, you can give them all of them the power to assign their rights to you. So all of them, you have paid them and say, for the next 20 years, I'm not going to pay you anything that arises out of this song. And so I am the executive producer. I have paid you X amount of money. You have assigned all your intellectual property rights to me, and then you can proceed. So in this scheme of things, it's possible that you have these 5 different people all having an interest in this particular song.
Okay, so Kofi,
yeah,
there are about 2 questions combined in one.
Mm-hmm.
The first one is on the assignment of interest. You know, typically in our Ghanaian settings, we sign contracts. We don't usually sign contracts with artists. They just manage out of good faith.
Mm-hmm.
If I'm an underground rapper,
mm-hmm.
I get signed on to a record label,
mm-hmm.
does it then mean that they own my intellectual property rights with respect to every work that I bring out? And then 2, I know there are 2 kind of rights in this IP system. There's the economic right and then the moral right. Mm-hmm. If I'm signing a proper contract, which one am I signing? Am I signing the moral rights to the person, or am I signing both moral and then the economic rights?
Okay, so the first one is the first one relates to contract and how the assignment is. Now now when you don't have a contract, it doesn't mean that the executive producer or your producer owns all the work. It now becomes that the work is still owned by you. You are still the author of the work, and you are entitled to enjoy the fruit of your labor. Now, what can happen is this, that the moment maybe the person has refused, so let's take for instance, you are an undergrad artist.
Now, a typical example, now this lady, she leaves Links Entertainment.
What's her name? Is it Miss V?
Miss V. Miss V leaves Links Entertainment. Does it mean that any works by Miss V whether or not a contract is signed, once he leaves the record label remains with the record label, because there are instances where artists are banned from the record label not to play some kind of music, any of the music that they produce during their time at the record label once they leave.
So you see, we have to look at what went on into the contract. Now, as I said, a musician can be just an artist, a singer, or perform the song. So the moment the person, maybe there's no contract, so the person can't perform the song because he's the one, the person's voice is associated with the song. You get it? So the person also has an intellectual property in the song. As I earlier on said, that it's so possible that 5 people will have an interest in the song. So the executive producer's right is only just a part of the work. So maybe the person, maybe for instance, maybe wrote the lyrics of the song. You cannot tell her that she cannot perform the song because the lyrics are hers. You cannot say, for instance, maybe she sings, she cannot use her voice to sing the lyrics. Do you understand? It's about what encompasses the particular work. How can we divide the work into various aspects for us to indicate whose work is this? Now, it may also be that there may be a dispute. So an artist is signed onto a label as an undergrad artist. They never sign a contract. After 5 or 10 years, they part ways. The song becomes an instant hit. Now the issue is, who has to benefit from the royalties? Is it the artist or is it the executive producer? Now, in this instance, the court will look at the situation and say, okay, the person brings an action. Remember that there's also what we call statute of limitation. When can you bring an action? So you composed a song 10 years ago, you didn't have any intellectual property rights, then you began an action. The court may look at the situation and say, because of equity, you are still the author of the work. Somebody is
you may not be the owner, but you are still the author
of the work. So as the author of the work, you are entitled to some benefits, some royalties. Now, what then is it? It means that the person who has infringed on your intellectual property rights will not be asked to pay you all the monies in retrospect, because you may be statute barred. Do you understand? So the royalties may be prospective instead of retrospective. So for instance, there's an English case called Fisher, where in this case, they never signed a contract. The song became an instant hit because it was used in a movie on Netflix. The person then brings an action and says, look, you owe me X amount of money from when we performed the song till date. The court said, no, your intellectual property rights has been infringed, but you cannot get because you had no paperwork. And in this instance, you are statute barred. So your rights are only prospective and not what? Retrospective. Now back to the other question on the moral rights and then the what we call
economic rights.
Economic rights. So when you sign the contract, usually you are doing the economic rights issue because you are signing the revenues that you would have gotten from the work to someone who then becomes the owner. The moral rights deals with the right of attribution or paternity and the right of integrity. So when we say right of attribution or paternity, what you're looking at is a situation whereby every father wants to be called paternity test, isn't it?
Once you mention paternity, it reminds me of court DNA test and stuff.
Exactly. So once every father wants to know his child, isn't it?
Yes.
And every child wants to know the father, isn't it? So what you have is that I want to wherever the work is used, I want to be acknowledged. Do you understand? I want to be acknowledged as the owner. So that could also form part of the work. So although somebody owns the work, somebody is the author, is the owner of the work. He's not the author. So for instance, you realize that what do you call it? Beyonce's song recently that he did with Shatta Wale. You realize?
Yes.
You realize that if you look at the album itself, when you read the credits, okay, Beyonce, Shatta Wale, all these people's names are mentioned. So although the album belongs to the Beyonce is the owner of the album, the entire album is not owned by her. Do you get it? Because there are various artists in the work. So there's somebody who used a certain costume. So you cannot go and pick. You cannot go and pick the video. Somebody cannot go and pick the video, look at the costume and use it to design the fashion designer who is on the page. Use the design of that to do another work. Then you have the integrity. So somebody composes a song in a certain way. You cannot just use a song, or somebody, what do you call it, draws or paints a picture. He has a right of integrity that the work will be in a way that he wants it. So you cannot just pick the work and sort of rubbish it and use it in a certain way that denigrates the work. So the contract, if you sign a contract, you may be signing a contract which only has economic rights. You are signing only the economic rights, but it may also be that you are signing a contract that sort of protects your moral integrity and also acknowledges you at your paternity.
Sure. So I'll come back to you. Let's go to Kwalezi, the artist manager. Kwao, are you there? Hello, Kwao.
Hello, I'm here.
Yes. So I mean, practically, what are some of the things that goes on between the artist and manager with respect to the ownership of their song? Because you may boom an underground. It will get to a time a typical example is the case of, say, Strongman Berner, Mike Bernes, or Amrab Berner and Mike Bernes. You boom an artist. He may have 7 songs during his time at the Mike Bernes. Now, Success Music signs a new contract with, say, with Strongman. Typically, do you have any arrangements with your underground rap artists throughout the time that you are grooming them? That's what I want to find out. Or what are some of the challenges that you face as artist managers during the time that you are bringing up your artists till the time that they become hits?
Sure. Basically, sometimes it depends. It depends on the time. There's always a time frame, right, for an artist to even get the blow. That's the hit song. Sometimes it even takes 7 years, 8 years. But most of the time, when we pick these people from the scratch, we don't even go about signing contracts with them, right? Most of the times, because of the kind of relationship we have with them, we sometimes go for the verbal contracting. I'm working with you for some time, and then we start the contracting when you see it's becoming fruitful. But with issues of signing artists, the contract is basically on an agreement, and the agreement is basically on you and the person involved, which is the artist. You will decide to, let's say, own 50% of the rights, or 70, 60. It depends on the agreement you have with an artist. But most managers, and most artists, because they don't know what it really entails, can go for, let's say, 70-30 or even 100% copyright. When you leave the label, you can't perform the song anyway. It happens most of the time. Now, when you leave a label, your own song, you can't perform it anywhere. It's just out of your zone. So it depends. But as I would say, we try as much as possible to make it look like it's a family thing. So even here, because here in Ghana, we don't even have the structures to, educate like as we are doing now, educate people about the copywriting thing and how it's going to affect you one way or the other. We try as much as possible to use what we call the years to determine how long you are going to be with a label. When you leave the label, you take your song, you take your stuffs, you go. So basically, that's what we do.
Okay, so in effect, it's more of a good faith contract because I know most of my friends who are managers picks up, say, young people, even from their parents, stays with them, grooms them, and then later when they become hits, one big artist comes in to take them away without any reverence or without any economic benefits to the manager. Is that the case as it is?
Most of the time, that's the case. It's of recent times that we are trying to learn about all this, and then we are trying to implement it. For the fact that when you see the person from the scratch, you have to get paperwork with the person. Most of the time, we do it out of love because scouting talent used to be out of love. Like you just have to cherish what the person does. You pick the person from the scratch. Let's say the person is trying to make, while the person is even trying to make it to the limelight. By the time you realize, then somebody more, let's say, intelligent in quotes will come and pick the person with paperwork, and then you are just going to make the noise, and then at the end of the day, the person will leave.
Yeah, I understand. I understand. All right, so thank you all, thank you all, thank you all. This program is called The Lawyer's Diary. The Lawyer's Diary comes your way every weekend with an issue, a legal topic that is worth discussing. Now, we'll come back to lawyer Nettie. In terms of IP or intellectual property rights, is there a duration for which my rights exist? Is there a status bar? Am I limited with respect to time when it comes to copyright? Is there a time limit to copyright issues?
Yeah. So okay. So let me just see. These three areas, you are looking at first trademark. So for instance, trademark, when you trademark a design or work or a name, the trademark is usually for a lifetime, so long as you renew the license. Now, for patents, you are looking at 20 years from the date the patent is filed and approved. So what it means is that the reason is this, that we don't want somebody to have a monopoly over the patent. So for instance, the people finding a cure for coronavirus, they'll only have a patent to valid for 20 years. After 20 years, the formula that they use to manufacture or the chemical compound that they use to manufacture the coronavirus cure will then be made available to other companies who can then copy it, because we want that after the 20 years, the assumption is that after the 20 years, the companies that went into producing this particular drug would have received the full rights of the economic benefits. For copyright, you are looking at the lifetime of the author plus 70 years after the death of the author. So if you are 40 years and you live for 50 more years, that is 90. So in 2020, you filed your copyright starts from 2020 till 50 years from now is 2070. 2070 plus another 70 years. That is 2140 or 2140. So that is the duration within which you have your copyright. So that's when the copyright lasts. So I think there's someone, Joseph Nyaba asked a question about in the 70s, some artists in the Upper East were signed by key European record labels, and because they were illiterate, their family don't know about these songs and their contractual agreement. How can they check? So usually, most of these songs, if you come across it, the moment you make a complaint, you file a complaint, if they know about it, if it is, for instance, on a streaming site like iTunes, on YouTube, on Spotify, and all the other things, the moment you get in contact with them, that you are the copyright owner. Because the thing about copyright is that copyright can be willed or can devolve to the beneficiaries of a testator or of an intestate person. So those persons can always file a complaint at any of these streaming sites, or if you happen to be in Europe, you can file a complaint in their copyright office or bring an action against these European recording labels.
All right, so if I understand you well, after the death of, say, the author or the owner, any member of the family can institute an action. Say if any music is being sampled without the consent of the family members of the author or the owner.
Yes.
Who has the capacity? Is it any member of the family? Is it restricted to the children? Is it the estate?
So it will if it's the person died with living a will, there will be the executors.
Okay.
The person dies intestate, then it will be who inherits the person, the beneficiary of the person.
So if no probate or say LA is taken, can any child, family member institute the action without proving that he has a probate or letters of administration?
No, what would be your capacity then? You remember
as a child, or as a family member, as a wife, or as a grandchild.
But you realize that under our laws, I'm not talking to the legal lawyer.
No, 90% of our they are not lawyers, so don't talk like a lawyer.
So what will happen is that when somebody dies without leaving a will, you are supposed to apply for what we call a letters of administration. So the letters of administration is what gives you the power to be able to distribute properties of other persons or to seek benefits of the property of the deceased person. So the letters for administration can only be given to the spouse, can only be applied by the spouse, surviving children, or in the absence of the surviving child, the head of family, or the customary successor. So in this instance, if the person dies without leaving a will, the family, the person has wife and children. The wife and children must apply to get letters of administration first, get the letters of administration, and be able to use the letters of administration to be able to bring an action against the persons who have infringed on their copyright. Other than that, you would be committing intermeddling, the offense of intermeddling. That is, you don't have the power to distribute the property of a deceased person.
Okay, so now there are two instances which I want you to clarify before we draw the curtain down. Recently, Nana Boro sampled some songs from J.R. Adolfo. Can assist us with the title of that song? Nana Boro and then J.R. Adolfo. It was basically, what was the title of that song?
Nana Boro
boy something. I've forgotten the.
Yeah, he used the Nyasemche. The
same beat was used, the same lyrics, some part of the lyrics was used, but there was a bit of dynamics in the song.
It was fanboy. Nana Boro fanboy. Yeah.
Nana Boro fanboy. Similar incidents like that. In that instance, can we say that there was a bit of improvement, or say about 80% was sampled from the original song without permission?
Yes. So if it may be that Mr. Adolfo has not heard about it, and he has not heard about it, or his management has not heard about it, so they have not taken any steps. But obviously, he has adapted the work. So as I said earlier on, yes, the song may be somebody's work. You are entitled to adapt the work, but you cannot adapt it without the permission of the person. So, for instance, if the song is on iTunes right now, and Adolfo is able to prove that, look, I am the owner of this original work, iTunes will pull it down. I think even if you watch, looking at the media landscape, one company, one organization I commend very well is Asase Radio. Now, if you look at Asase Radio, their online streaming, their Facebook streaming service, anytime they are streaming, they put an objection there and says, look, we are streaming live, all the songs that are being played, all the comments,
background.
we don't own the intellectual property rights to these songs, or we don't own the reports to these songs, to these works. So they put the objection. So everybody knows that, look, I don't own, they only own the production or whatever they are doing, but they don't own the song that they play. So you cannot report to Facebook that there has been what do you call it, a violation of your rights. If you go back to the earlier example I gave about Mr. Drew, for instance, once this attention is brought to YouTube, YouTube will likely pull down the song. You realize that there are some movies on YouTube, when the movie is playing, especially some of these are local films, Kumawood movies. You realize that when the movie is being played, the song in the background doesn't play. It is just because YouTube has cut those songs from the background because they are not sure that you have sought
the person's permission, the owner or the author's permission.
The artist's permission to use the song. So because if YouTube uses a song on their platform, YouTube will be subject to copyright infringement.
Okay, so there's also another case, a practical case study which I want us to also discuss. Amram Bernard, and then ASEM, ASEM ASEM. Mm-hmm. So ASEM usually did a yearly song in a form of rap, capturing all events that happened within the year. Mm-hmm. And then recently, Amram Bernard also did a weekly newscasting in a form of events that happened in the course of the week in a form of rap entertainment. Mm-hmm. ASEM threatened Amram that is my concept, that is my intellectual property, that is my invention. Mm-hmm. And threatened him that if he continues to use that, he's going to sue him. Mm-hmm. So now my question is that when it comes to concepts, when it comes to ideas, when it comes to newscasting, I mean, daily happenings that comes off in a daily basis, can you even register a copyright? Can you register anything in terms of intellectual property on a concept, on an idea, or on anything related to news?
No. So there's a concept we call permitted use, which our law also recognizes. So these are exceptions to copyright and allows what we call limited use of the copyright work without the permission of the copyright owner. So, for instance, if a photographer takes a picture and you use a picture, somebody draws a painting and you take a picture and put it in your room. It's personal use. You don't need the consent of the owner. If somebody plays, that's why you are able to, for instance, play music in your car without paying copyright. You're able to play music on your phone without copyright. But the moment you set up, say a hall,
a restaurant,
a theater, and then you use a song to commercialize those songs, then you have to pay copyright. Or for instance, you do what we call sufficient acknowledgement. So you acknowledge the person that, look, this is the person's work. So back to our paternity test analysis, you don't need the person's consent. Then, for instance, you are not using it for any non-commercial research activity, or it's just for private study or for private work. Teachers don't need copyright. They don't need the permission of the author to be able to use teaching materials to teach students. So news reportage, you don't need the consent of the owner of the work to be able for the media to be able to use it for news purposes. So Sarkodie has played a song, and then the newscast wants to make a story out of the song. They don't need Sarkodie's permission to be able to use the song for the news item. Also, republication of say current news or political topics or economic or religious topics, you can use it in news reportage or any other way. You can reproduce them without the consent of the owner, unless the owner has specifically said that you cannot use this without my consent. So if the owner specifically says that you cannot use it without my consent, it's not. Now, if we go back to Amrado and Asem's issue, Asem is totally way out of line because Asem doesn't own the right to news reportage. News is news. Nobody owns the copyright to news. And also, Asem performs his song. The rap, the content are not the same. So you don't have copyright over ideas. You have copyright over works, things that you bring there. So Amrado is not copying his work that he did because Asem's filler 10 years ago is not the same content that Amrado is performing on a weekly basis that you have. So they're totally two different things.
That's nice.
All right, so it's 7 o'clock. We've exceeded the time that you gave to us. Let me.
I think there are two questions I probably would.
All right. Please address the questions and then let's.
One from Valentine that says that the Chief Justice has set up a creative arts course just for intellectual property. Do I think it's a step in resolving these IP? I think yes. I think it's a good step, but I think that there's more to it than just there's more work to be done just the mere fact of setting up courts. The court itself is not everybody that wants to go to court. Issues must be resolved one way or the other. But having a specialized court may sort of speed up the processes or the litigation surrounding IP rights issues of creative. So this is in good order, but we just need to develop our structures more. Then there's also the question of how from Niyama Kweku that talks about registering an idea. So you don't register an idea, you register a work. So you cannot, other than that, nobody else, nobody else can go around developing anything because everybody will say, I had the idea of doing something. So you register a work. So if you have developed a work, you can, if it's a book, for instance, you have a copyright over the book. So there's a copyright office that you can go to and register the copyright, the book. If it's a song, you can. If it's a trademark, is a design, for instance, which is a trademark, you can go to the Registrar General's department and register the name as a trademark or the design. Then so basically those are the two questions I would like to address.
All right, so Sami, thank you very much for your time today. We really appreciate it. We wouldn't want to waste so much of your time. Today's episode is sponsored by Goal Achievers Company Limited. They are into wallpaper, biogas installation, 3D epoxy, and window blind. They can be contacted at 0247 505 235. 0247 505 235. And for those of you also asking whether we are going to share the content of what we just did, I've displayed our social media pages. So on Instagram, we are Lawyers Diary Global. On Facebook, we are the Lawyers Diary. And then we'll entreat all of you to subscribe to our YouTube channel, Lawyers Diary, and then follow us on Twitter at Diary Global. After every session, we upload the videos on YouTube. So kindly go to our pages, all of you. There are 20 of you here. So I'm expecting that probably by the end of the day, we have 20 more subscribers on YouTube. Lawyers Diary, subscribe to our pages, and then watch our videos, share our videos, so we can expand the audience. If you may have any question, you can unmute yourself and ask before we sign off. All right, Richard, are you good with everything that's happened? Kofi, Sami, and everyone. Kofi Amponsa. All right.
Yes. I think so far so good.
All right. So Richard, can you go and then subscribe to our Facebook as well as our YouTube channels, and so that you also become aware of our upcoming programs. Every Friday or Saturday, depending on the availability of our speakers, we discuss an area of law on weekend basis. So, Paulus, thank you. I know you're very busy. I know that on Friday evenings at 6 o'clock, that's when you release your ESSM and then also monitor it. So to get you this panel is really something that we appreciate.
Sure, I'm trying to do this and monitor it as well.
Yeah. That's why we didn't worry you too much.
I urge everybody to go and watch it. We are having over 5,000 views now. So.
Oh, nice.
Yeah.
Okay, so talk to the viewers about YETSM before we sign off.
YETSM is one thing. It's a new thing. Let's say it's a new thing by Amrado, a Ghanaian rapper. He summarizes every trending news in the week and deliver it in a form of rap. Instead of we seeing our newscasters do it, he delivers it in the form of rap, and it's always on his YouTube channel. Friday, 6 p.m. You can have a look at it. It's interesting, so you can watch and then laugh at it.
Also subscribe to his YouTube channel on Amrado Bena. Amrado Bena.
That's the name.
Yes. So, lawyer Samuel, thank you very much for your time, and we are looking forward to having you in Ghana once the borders are opened. Hello, Sami. All right, so I think Sami just dropped off. Thank you all for your time. It's been a pleasure having you, and we appreciate your time. Thank you. We are off. Yes.